So I'm Tricia Crowley, president of the Champaign County League of Women Voters, and we're really happy this evening to have a couple of speakers who are going to really tell us what's been happening with the criminal justice reforms that we were all excited about last year, to see, if the ones that have been implemented are working, if how they're working on the question of money bond, which doesn't go into effect for a year, and also if there are efforts to sort of undo some of this at the legislative level. So with that, I'm going to turn it over to Sarah Staudt, who's with the Appleseed Center in Chicago and working on these issues. So Sarah, take it away.
Great. Thank you all so much for being here. I'm here with my co-presenter, Akeisha Lee. Akeisha, you want to introduce yourself?
Yes. Hey, everyone. So my name is Akeisha Lee, pronouns she, her, and hers. I am in Chicago. I'm an organizer with Southsiders Organized for Unity and Liberation.
I'm actually going to have Akeisha kick us off. So what we're going to do is we're going to go through, we're going to start by going through what's actually in the bill. I think there's a lot of people who there's a lot to say about why we decided to pass the bill that we passed and what's in it. So we're going to go through that. And then we'll have plenty of time at the end for questions and to talk about implementation.
But it is a law. It's not a bill.
Yes, to be clear, yes, I say bill because I don't know why I say bill, but you're right. It is a law. Yes, it is a very real law that really passed almost a year ago now. So, oh no, more than a year ago now. So yeah, with that, I will kick it off to Akeisha. Akeisha, do you want me to share my screen?
Can you please?
Yes.
Thank you.
Do this.
All right, so for folks who are just joining, hello. We're excited to be here today to talk to you all about the Pretrial Fairness Act. My name is Akeisha Lee. I'm with Soul, and I'm here with my co-sponsor, Sarah Staudt from Chicago Appleseed. Both of our organizations are a part of the Illinois Network for Pretrial Justice. Next slide, please. Okay, so we're going to talk about why we focus on bond in the first place, the impacts of money bond, how bond currently works, what the Pretrial Fairness Act changes, how it makes our communities safer, and what kind of opposition we're up against even after the bill has become a law, and then invite you all to get involved with us. Next slide, please. So the Illinois Network for Pretrial Justice launched back in the summer of 2019. The network is composed of over 40 organizations that are all across the state of Illinois. They represent 9 different counties and several statewide organizations and other networks. Our members stretch from Carbondale all the way down to y'all in Champaign. Next slide, please. Okay, so I'm sure some of you all are wondering why we said money bond was the problem when there are so many issues within our system that we could address. So every year, more than 250,000 people are incarcerated in the 92 county jails across Illinois. And 90% of the people who are in jail are in their pre-trial. That's a much higher average than the national average of only 67%. So a majority of these people are incarcerated basically just because they can't afford to pay the money bond. And so what is money bond? So when a person goes before a judge, the judge can do a couple of different things between them and release. So first, the person could be released on their own recognizance under an I-bond, which means they can go home pre-trial without paying any money at all. The judge could deny the person's bond altogether and incarcerate them if they feel like they are a flight risk or a risk to their community. The judge could set a money bond that has to be paid before the person can go free. And with that, the judge can also set conditions of that release. So the person could be released and have to do check-ins with pretrial service officers, or they could be placed on home incarceration or electronic monitoring. And just to be clear, that when a person is given bond by a judge, the court has already determined that that person is cleared for release. So that judge has legally determined that this person is not a danger to their community. And the only thing between that person and their freedom is access to money. And because it's money, this is wealth-based punishment, and it's inflicted upon the person while they are still presumed innocent under the law. So if these people had more money in their accounts, they could be at home, maintaining their jobs, taking care of their children, etc. And the issue with money bond is that it maintains this myth that paying a money bond will ensure a person comes to court. And oftentimes judges are putting in place money bonds that are far too high for a person to pay. And this is often done intentionally to keep the person from being released in the first place. And this practice is unconstitutional because it denies the person due process and it discriminates against people who are poor, of color, and Black people in particular. And unfortunately, there is no evidence that money bond does anything to improve appearance rates. So there are bond funds who currently help people pay their bail, and people have found in those bond funds that when the person pays their own bond, they are actually less likely to come back to court than when the bond fund pays it for them, because it was in fact the support that they were given through simple reminders like phone calls and community support that aided them in getting back to court, not paying the bond itself. Next slide, please. Okay, so incarceration pretrial has some pretty significant harms that impact people well after they're released from jail and while they are also inside the jail. Just 1 or 2 days inside of pretrial incarceration can significantly disrupt the person's life and set off this destabilizing domino effect. This can cause people to lose their jobs and even contact with their children and their housing. If we fast forward to a month of somebody being incarcerated pre-trial, people begin to lose access to public benefits, and that can create gaps in their care for like healthcare insurance, Social Security benefits, even after they're released. And the first few days of pretrial incarceration is particularly dangerous for folks who are more vulnerable. So people with mental health needs and people who use drugs. And a lot of people die within the first 5 days of being incarcerated. Next slide, please. Okay, so all of this matters for the reasons said before, but also because when a person's incarcerated pre-trial, it makes it more difficult for them to fully participate in their defense. So people in jail pre-trial are more likely to be convicted and they serve longer sentences than those who were free awaiting their trial. And the pressure of pretrial incarceration can lead people to accepting plea deals just to get out of jail, deals that they might have otherwise decided to fight in court. So here we can see that if you are incarcerated pre-trial, there's a 4 times greater likelihood that you'll be sentenced to jail and a 3 times greater likelihood of going to prison. And once you get sentenced, they can be up to 3 times longer if you are in jail and up to 2 times longer if you are in prison. And locking people up who are presumed innocent also undermines our system's own stated goals. And that goal is to create safety and ensure people come back to court. So people who are in jail pre-trial are actually more likely to be arrested in the future. So that means that jailing people is literally creating more crime. And if we think back to what I said earlier about the harms and the consequences of this system, it makes sense because they're being barred from maintaining healthy relationships with their community and staying in contact with their resources they need to survive and succeed. So the less that we destabilize people by jailing them, the more safe and secure they can be, and the more safe our communities can be as well. Next slide, please. Okay, so now we're going to hear directly from folks who were incarcerated pre-trial.
I was incarcerated pre-trial for 2 months.
2 months, 3 months, 1.5 years, simply because I couldn't afford to pay $1,500.
$5,000. $7,500.
$25,000.
I lost my home. I nearly lost my son.
I lost my business.
I almost took a plea that I wouldn't have otherwise.
Not because of a conviction,
but because of an accusation. Our stories are unfortunately not unique.
They are all too normal.
Every year, more than 250,000 people pass through Illinois' jails.
250,000 people.
But we can stop this injustice today. The Pretrial Fairness Act will end money bail in Illinois.
The Pretrial Fairness Act will restore the presumption of innocence.
The Pretrial Fairness Act will allow hundreds of thousands of people per year to stay in their communities.
Working,
taking care of their family, and accessing services while awaiting trial.
Let's end money bail.
Let's end money bail
Let's end money bail.
Let's end money bail.
and bring our people home.
across Illinois.
Okay. Yeah, that video always really gets me. Before I pass off to Sarah, do folks want to just drop in the chat any emotions that come up for them when they watch that video? And at this point in the presentation, feel free to just drop it. And then with that, I'll pass it off to Sarah.
Oop, sorry, trying to get the next slide here. There we go. So what I'm going to do now is I'm going to walk through what's actually in the bill. So we call this a principled walk through the Pretrial Fairness Act because we actually go through the bill by talking about, by looking at a set of principles that were used to write the bill in the first place, and then looking at sort of how the bill ends up implementing those principles. These principles were developed by communities and organizers in those communities, so they really do represent what real Illinoisans wanted for their pretrial system. And we were really fortunate because of the strength of our legislative partners and the strength of our organizing that the bill that we ended up passing really has the vision that we wanted it to. And so it's really exciting to be able to walk through those principles and be able to say this is really in the bill. So the first principle is the one that I think everyone is the most aware of. Money is never a determining factor in whether someone is free pretrial. So the Pretrial Fairness Act ends all money bond in every case, every kind of case, every county. It removes money from the system entirely. And by doing that, we're actually the first state in the nation to remove money bond entirely. Although a lot of other states have come close, we're the first one to truly create a universal system that does not involve any money. So what did we replace money bond with? So it was important to us that we end money bond, but this principle was by far the most important principle when we were building the Pretrial Fairness Act. Release is the norm. Detention is the carefully limited exception. That language is actually from a US Supreme Court case. It's supposed to be the way that all of our pretrial systems across the country work, but the reality is that we know that it's not the case. That in fact, in many cases, jail is the norm and release is the exception. What we wanted to do is make sure that any bill that we passed that got rid of money bond and replaced it with a different system would do so in a way that decreased our jail populations. Ultimately, we would have seen this bill as a failure, and we would still see this bill as a failure if in the end we got rid of money bond, but our jail populations went up. Like Akeisha just said, the harm here, money bond causes harm, making people pay money causes harm, but jail causes the real harm in our pretrial system. And we want to make sure that as few people are in jail as humanly possible. So how did we do that? So what the bill does is it creates something that we call, and this is sort of like a nerdy criminology term, but a detention eligibility net. You can sort of think of it as like a net that catches some kinds of charges, but not others, and says, these are the kinds of charges where jail is on the table, and the other charges are places where jail is not on the table. What that means is that there are whole categories of charges where, so long as you're not on probation or parole, or you haven't already been released pretrial on something else, a judge will not have jail as an option when you're arrested. And that includes lots of lower level felonies and misdemeanors, everything from thefts to drug charges, places where we really don't think that the charge suggests that the person poses any threat at all to either the safety of any other person or a threat, particularly that someone is going to willfully flee prosecution. And we think that conditions of release are enough to make sure that they complete everything they need to complete. For a small number of charges, and I'll show a flow chart in a second, we do allow detention, but we increase the standard required to incarcerate people pre-trial. The other thing we do in the bill is to decrease, for very low level charges, we decrease any incarceration. So obviously, when you're arrested, you spend some time in lockup, and then you often spend some time overnight, and then sometimes a couple days in jail under the current system, sometimes a lot more than a couple days in jail. For very low level charges, we require tickets to be given instead of arrests and taking people into lockup, so that we're actually decreasing the amount of incarceration, even for those first couple hours that people can be incarcerated if what they're charged with is jaywalking or trespass or other really low level charges where there's just no reason to think that the person poses a threat to anybody else. Police are allowed to arrest in those cases if someone does pose a threat to other people, but the normal case, they should be issuing tickets instead of arresting. And the reason we did that is that we know that even a couple hours in jail can have a massive effect on someone's life. So this is a flow chart that sort of shows how the new system breaks cases into two different paths. So you're stopped and arrested by police. And we sort of have two different paths we can go on. I'm actually going to go to the bottom one first. Most felonies and misdemeanors, and the math is about 80% of people who are arrested in Illinois will fall into this category, will not be eligible for jail. Instead, they can either be released directly from police custody, or they can be held overnight and go to a hearing on conditions of pretrial release, where a judge can say, okay, well, I want to make sure that you check in with pretrial services, or I want to make sure you get court reminders, or whatever else the judge thinks is important and necessary to actually make sure the person does what they need to do. For certain charges where safety is a concern, and basically these charges are, and I can run through them, serious violent felonies, sex cases, all domestic violence cases, all gun charges. For those charges, the prosecutor has the choice to ask for jail. If they do that, it triggers what we call a pretrial detention hearing. Both parties have between 24 to 48 hours to prepare for that hearing so that they're really ready to make good arguments about whether jail is or is not appropriate in a certain circumstance. And the standard is that the court needs to find by clear and convincing evidence that the person poses a specific real and present threat to another person, or has a high likelihood of willfully fleeing prosecution. So it's a standard that's a little bit of that's really, where we hope will make judges think. It's a little bit above just a question of, do I think this person, might hypothetically pose a danger to the community at large, and says, no, what is the specific concern that you have about this person, and what danger they might pose to another person. Similarly, instead of asking, is this person going to show up at all their court dates, something that can honestly be addressed for most people by just giving them court reminders, we ask the harder question of, is this person a person who's going to willfully flee the jurisdiction? I would sometimes refer to this as the Rod Blagojevich case of people who, we might actually have a really good sense might actually skip town. So we ask judges to only use jail in those heightened circumstances where one of those factors is present. Otherwise, judges can release and impose whatever conditions they think are appropriate when they release someone. Our third principle is that accused people should be viewed holistically. We wanted to make sure that risk assessments are not used as substitutes for individualized decision-making about an individual person. If you don't know what a risk assessment is, risk assessments are algorithms, they're formulas that basically take a bunch of information about a person, plug it into a formula, and then spit out an answer, for example, an answer on a scale of a person is, between a 1 and a 6 in terms of how risky they are, how likely it is that they may be rearrested pre-trial. Those formulas have a couple problems, and we wanted to make sure that they weren't overused, which is something that's happened in a lot of other states where bond reform has gone into effect. The concern is that they can increase the role of systemic racism in the system, because the data that goes into them is based on, for example, things like arrest rates. We know that Black and brown folks end up with higher risk scores, even though they don't actually pose any more danger than white folks do in these kinds of risk assessments. So we wanted to make sure that judges aren't using a shortcut to decide whether someone is or is not risky. Instead, they need to view a person holistically, look at everything about them, their family, their employment situation, everything that they could, everything that you would want someone to take into account about you if they were making a decision about your freedom. So we limit the use of risk assessments in decision making. We say that they can't be the sole factor that's used to determine whether someone goes to jail. And we allow attorneys to know as much information as is available about those tools so that they can appropriately talk about them to judges. We also make sure that merely missing court is not used as per se evidence that someone is going to miss court in the future or is going to willfully flee prosecution. What we know from research is that people mostly miss court because of factors either beyond their control or because of just simple human mistakes. In most jurisdictions in Illinois, we don't give court reminders. So like I get a reminder for my haircut when I get a haircut, but we actually don't in most jurisdictions send reminders for people to come to court. So most people miss court because they forget. We know that when we actually give court reminders, there's a double-digit % jump in people who appear in court, which really tells you that it's not that people don't want to come to court, it's that they don't have the tools that they need. So we basically make sure that that missing court isn't treated as something that means that forever you're going to be viewed as someone who's never going to come to court again, because that's just not accurate. Our fourth principle is that court should help accused people attend court hearings and should restrain their freedom as little as possible while they're legally innocent and awaiting trial. We reform the warrant process. So what we do is we allow, one of the things that happens in the current system is that when people do violate the terms of their pretrial conditions, so if they fail to appear in court or if they fail to appear for a meeting with a pretrial officer or something similar, a warrant is immediately issued for their arrest. And that can be really disruptive to people's lives, right? Because suddenly they have a warrant that they don't know about and they get stopped by the police or pulled over, or someone knocks on their door with a warrant and suddenly they're plucked out of their lives and out of their families' lives in ways that can be really traumatizing and terrifying. So instead, we give judges the option of giving people a grace period. If they do violate the terms of their pretrial conditions or they fail to appear in court, give them a grace period of 48 hours. And if they appear in court within 48 hours, they aren't given a warrant and they don't have, someone coming and arresting them out of their daily life. We also put some limits on pretrial conditions. The biggest place that we do that is with electronic monitoring. Electronic monitoring in most parts of Illinois is basically used as house arrest. So people are given an ankle monitor, but are told that they must remain in their house 24/7, just like if they were in jail, but in their home. It's maybe more comfortable, but in terms of the effect on someone's life of actually being incarcerated, it really can have a lot of the same harms that being incarcerated in jail does. So we put some limits on this on the logic that it's pretty much the most severe kind of pretrial condition that you can impose on someone. We require judges to reconsider orders of electronic monitoring every 60 days. We require that people be given movement, which means permission to leave their house to do essential tasks. One of the things I always like to say to people is, when people are in jail, we feed them. When people are on electronic monitoring, when they're incarcerated in their homes, there are lots of places in Illinois, Chicago in particular, where people, before this law went into effect, didn't have permission to go buy groceries. So basically, we were incarcerating people somewhere where we weren't providing for their basic needs. So we require that they have permission to meet their basic needs. We increase how seriously someone needs to violate the rules of electronic monitoring in order to be charged with a new felony called felony escape. We require that somebody actually be out of compliance and have broken the rules for 48 hours before that can happen. And then we also make sure that electronic monitoring is treated like custody, because it is custody. So every day that people spend on house arrest, they need to have counted against any sentence that they're ultimately given if they are convicted of a crime and sentenced to prison. Our fifth principle is that courts should only use restrictive pretrial conditions to ensure court appearance for people who have been proven to be willfully avoiding prosecution. What we mean by that is that we want to make sure, and I mentioned this a little bit earlier, we want to make sure that courts are only using, really heavy-handed conditions when they're necessary. And there's been some proven necessity that shows that this is really what someone needs in order to succeed and to appear in all their court appearances. One of the things that is the biggest concern now under the current system is the way that violations are treated. Basically, people, if you kind of get one shot, and if you violate even a little, people can end up locked up all the way until trial. That's an extremely restrictive way to treat people that really doesn't match the seriousness of what happened. So we require that instead revocation have an actual process attached to it, much more so than it does right now. And we bar permanent revocation of pretrial release for most violations. We cap how long someone can be incarcerated for missing court or for violating their pretrial conditions at 30 days. The last principle that we were focused on in the Pretrial Fairness Act is that pretrial practices should be transparent and accountable. So the bill creates a statewide data collection and publication process. Right now in Illinois, every county practically uses a different system for how to record their pretrial data, which is very frustrating for a researcher like me. It also means we really don't know what's going on around the state in terms of how many people are in custody, how many people are coming to court, how many people are getting arrested while they're released pretrial, all sorts of really important things to know to make good policy. So there's a board that's already meeting, actually. This part of the bill went into effect last July to first standardize the data collection for the whole state so that everyone's using the same system, and then make sure as we go forward that there is public collection of data and publication of that data so that we can all see how well the bill is working. We know that we're going to face a lot of opposition, and we want to be able to point to real data and say, hey, we can tell that what we're doing is working. With that, I will turn it back to Akeisha.
Thanks, Sarah. Okay, so overall, there is no safety in a system that finances determines who is and out of jail. The Pretrial Fairness Act makes us safer by ensuring that finances do not determine freedom and that a fair process does instead. So reducing incarceration reduces crime because data has shown that pretrial incarceration increases the likelihood of future arrests. Because, as Sarah said before, jail is isolating and a violent place that further stigmatizes people who are traumatized. People do not get help in jail, and the shame, the stigma, and the hurt it causes can even increase the likelihood of future contact with criminal legal systems and future violence. And already, several jurisdictions have eliminated money bail or greatly reduced its use, including over here in Cook County in Illinois. And notably, this reduction has happened without endangering community safety, and in some instances coincided with the overall reduction in crime. Next slide, please. Okay, so to talk a bit about cases that involve allegations of violence, I'm sure it's on your minds. So a lot of elected officials will talk about how bail reform for people facing nonviolent crimes, especially centering people who are alleged of committing drug charges. But our vision includes everyone. So it's important that we don't leave out people who are accused of more serious things in the PFA. And we think it's important that we talk about why and acknowledge how that can cause discomfort for some people. So we believe that all people are deserving of their pretrial freedom, regardless of the accusations against them. And at the foundation of our legal system is the principle that we are all considered to be innocent until proven guilty. And that should apply to everyone. And we have to wrestle with the discomfort that we feel around releasing people who are charged with more serious crimes and recognize that doing that is a direct violation and contradiction of our principle. So currently we are locking people up, sometimes for years at a time, simply because of an accusation. And this is destroying families and tearing apart communities. And it really is making our system one that makes you guilty until you are proven innocent. And that's not okay. And that approach is not making us more safe. As we talked about earlier, jailing people destabilizes their lives and makes them more likely that they'll be rearrested in the future. So just because a person has been accused of a crime doesn't mean that they are a danger to their community. So we can see here on the slide that between October 2017 and September 2019, 98.7% of people identified by Cook County's risk assessment tool as being a high risk of being rearrested for a new violent offense were not charged with the new violent offenses. So out of like the 30,000 people who were released in the last 2 years that have been accused of committing violent offenses while out on bond, 99% of them did not do anything else that endangered their community or their safety, and they were successfully returned to their communities. Next slide, please. All right. So I said before at the top of the hour that we're really excited this bill passed, but there is still things we have to think about and guard against as we move forward to implementation in this year and next year. So one is the changes to legislation that could cause more people to be incarcerated after our law is implemented rather than few. So for example, opponents may want to drastically expand the detention net that Sarah was talking about earlier. That's the charges that qualify people for pretrial incarceration. And it's important that we stand up against this for all the reasons we discussed previously. So being charged with things that are more serious does not mean that someone should automatically lose their right to pretrial freedom. Every person deserves to have a fair hearing process that gives them the least restrictive condition necessary to ensure safety. So the Pretrial Fairness Act must be maintained intact in order for that to happen. So now I'm gonna, actually no, one more slide, sorry. Next slide. So last is risk assessment tools. So the Pretrial Fairness Act is gonna limit how risk assessment tools are used in pretrial decision making, but there are still many people who rely on them to drive release decisions, especially now that we've ended money bond. So these tools were developed to help reduce the chance that judges are making decisions based upon their own biases. But as we know, the algorithm itself was created with bias and the system just repeats that bias. So in a lot of ways, these tools are measuring the criminal justice system's own response to its own bias, rather than how they're gonna act if they are released. So the decision-making practices of judges have been shown to be subject to implicit racial bias, classism, and overall in some ways problematic, but that doesn't mean that we should rely on assessment tools that rely on that other bias talked about earlier. So despite these issues with these tools, they will continue to be in use in Illinois for the time being, but the introduction of assessment tools is something that may happen either at state level or the county level. So Illinois Supreme Court wants to develop a statewide risk assessment tool. And many are pushing for things to be included in that tool that we know will increase bias and ultimately deepen racial disparities in our system. So we're going to continue to push against this and give you opportunities to work with us in this next couple of months, a year, to make sure that things that we need to put in place are in place. And is next one mine too, Sarah? I'm passing off to you. It's me?
Yeah.
Okay. Okay, so overall, we know that people need resources, not surveillance and not monitoring. Many false alternatives to incarceration are being offered up in response to calls for real reform of our pretrial justice system. At the forefront is electronic monitoring, or EM. So through the PFA, we protected more rights people who are on EM, but we still need to fight against the drastic expansion of EM once the PFA goes into effect. So many counties in Illinois do not currently have pretrial electronic monitoring programs, but they may try to start them if they can't jail as many people that are out on unaffordable money bonds. So we must work to prevent this with the data collection mandated in the Pretrial Fairness Act, because that will monitor how many people are on EM and help us track this. So people must work in the individual counties to oppose the creation and expansion of EM and GPS monitoring programs and demand that no new investment in these services are granted. If few people are in jail, the county should take the money from the jail budget to invest in communities. not get more money to find new ways to surveil people in their community. And we can talk more about that in the question section. And with that, I'm going to pass it over to Sarah to talk more about how you can get involved.
Yeah, so I actually am one of the things that y'all asked me to talk about was implementation. And Akeisha just went through, I think, 3 of the biggest things that are going on in implementation right now and some of the challenges. And I've got some of them here as well on the screen. So it's a little looser, but I wanted to give you a sense of sort of what's going on with implementation, what different counties are trying to do, and what kinds of support people who support this bill could give their own communities so that this bill ends up going into effect successfully. So if you couldn't tell, and I'm sure you could, we are overhauling our pretrial system. This is probably the largest change, like single change to the Illinois criminal system, at least since the 80s, in terms of the way the system functions. That is a lot of work. It means that every individual jurisdiction needs to do planning in order to implement this successfully. Unfortunately, there are a lot of jurisdictions that are behind the ball on this one. Cook County does have implementation working groups that have been meeting for about 3 or 4 months now. And a number of other counties are starting to have those groups too. But we actually really need people to ask their own elected officials, to call up their prosecutors and their chief judges and say, hey, what's your plan for implementing the Pretrial Fairness Act? The reality is that in terms of resources, we truly believe that the resources involved in this bill will balance out. Primarily when other states have gotten rid of money bond, they've seen cost savings because they're jailing fewer people, and jail is by far the most expensive way to treat someone pretrial, right? So when you free more people and spend less on jail, ultimately you get a big bang for your buck on savings. But we need to make sure, but there are a lot of individual jurisdictions who I think haven't totally internalized that and see the end of money bond as something that's going to mean that their revenues go down. So we really need people, particularly if you're the kind of person who is interested in your county budgets, to talk to their elected officials, make sure that they understand, make sure that if there is money that they need to implement the Pretrial Fairness Act, that they're getting it from their county budgets or getting it from their state budgets. There will definitely be state appropriations asked for from counties to implement this. And also, make sure that they understand that this is really happening and they really do need to devote resources to it. As Akeisha was saying, and I think this is really key, I think there's an impulse when we get rid of money bond to snap into a system that has over-reliance on restrictive conditions, surveillance, and mandated treatment for released people. And I understand that impulse, the idea of, oh, well, these people used to, were in jail. So therefore they must be that they need to have lots and lots of restrictions when they're out. The reality is the research shows that that's just not the case. The only pretrial service that has been shown to increase court appearance rates is telling people when they have court. Treatment, check-ins with pretrial services officers, electronic monitoring, none of them have actually shown that they even help. Which is sort of counterintuitive, but it's the reality. And it has to do with that destabilization of people's lives. People do better the less that they are interfered with, is the general understanding from the research. So we need to make sure that our individual jurisdictions aren't defaulting to that idea of increased conditions. We also need to make sure that, and this is something that needs to happen at the state level, that we provide the training and administrative reforms necessary to implement the law. We need to train all our judges in Illinois. The AOIC, which is the Administrative Office of the Illinois Courts, is doing some good work to pull together trainings for judges and otherwise, create the supports for counties that are needed. But we're definitely going to have to stay on them to make sure that happens, because if judges aren't properly trained, none of this is going to work. So again, if you are the kind of person who is involved with your local court system, ask questions. We really need people to be pushing to make sure that that jurisdictions are taking these changes seriously and know that they're really coming, and that hopefully ultimately that they can get on board with the idea that this is a reform that benefits everyone. One of the things we didn't mention in this presentation that I always like to remind, or let people know if they don't already, is this bill was the first major piece of criminal justice legislation in the nation that was passed not only with the support of criminal legal system reform advocates like myself and Akeisha, but also the support of crime victims advocates. The Illinois Coalition Against Domestic Violence, the Network Advocating Against Domestic Violence, Chicago Alliance Against Sexual Exploitation, where three of the first two actually represent about 120 domestic violence groups from around the state, all not only supported the bill, they actually helped us draft it. And they did that because they think that a no money bond system is better for survivors of crime. I truly believe that this system is better for everyone. And I think that I'm hoping that if implementation efforts are taken seriously, that other players in the system will start to realize that that the money bond system really was an illogical and ultimately ineffective way to run our court system, and that a new system benefits everyone. So how can you help? The biggest thing you can do, and this is real, this really is helpful, is thank your legislators. If they voted for the Pretrial Fairness Act, get in touch with them and tell them that you appreciate them. If you go to our website, which I'll put up in a sec, we actually have a letter writing tool that you can use to do that. A lot of our legislators are getting a lot of pressure to sort of crack down on crime and return to a lot of policies that might remind us of like the 90s. They really need to hear from people who support criminal justice reform. You can stay up to date with us by following us on social media and signing up for our newsletter, and raise awareness. One of the things that I always say, particularly to groups like the League of Women Voters, is we, and particularly folks like you who are from downstate, not downstate, but mid-state, is your social circles are likely the places where people have the most misinformation and some of the strongest fears about this bill. The sort of the opposition that has been sending out the message that this bill is going to make us less safe has been targeting mostly suburban and small city, upper middle class groups, and trying to convince them that this is going to be the end of the world. What that means is that if you support this legislation, your voice can be really powerful within your own networks. So please don't assume that you are in a bubble. Don't assume that everyone around you agrees with you. Talk about this issue. Talk about why you support criminal legal system reform, and help us educate some people and change some minds. Thanks. So we're happy to do questions. If you want to contact us, info@endmoneybond.org, and our website is endmoneybond.org. And if you are a Twitter user, we are @endmoneybond. If you're a Facebook user, if you search for Coalition to End Money Bond, you will find our Facebook page. So that is our presentation. I'm going to stop screen sharing so that I can actually see people. And I'd be happy, and Akeisha would also be happy to stick around and answer any questions anyone has.
Well, thank you, Sarah and Akeisha. And I think probably people do have some questions. I guess I'd like to start by saying, are there parts of the bill that have been already implemented, and what are those parts?
Mm-hmm.
So just a couple. There are two working groups, one on data and one on domestic violence, both of which have started meeting. So those were sort of groups that, they're really planning groups that have already started, but that's one part of the bill. And then the electronic monitoring provisions that we talked about went into effect on January 1st and are going fairly well, at least in Cook County. The sheriff is following them. People are getting more freedom. So we're really excited. It was some work to get it implemented, but so far, so good, at least in Cook County, for the parts that have gone into effect so far.
And when is the projected start date for the end of money bond?
January 1st, 2023.
Okay. And Jane, you have a question. Why don't you ask it yourself? You can unmute yourself.
Yeah, so, there are a lot of people who think, oh, this is terrible and this is why bad things are happening. So I'm hearing three things. One is, oh gosh, repeat offenders go to jail briefly or let go and then they offend again. But the money bail provisions aren't even in effect yet.
Right.
So it's complete BS.
You said it, not me, but yeah. Yeah, if you hear anyone blaming anything that's currently happening in the world on the end of money bond, they are misinformed. Money bond has not ended yet. And we are hearing some of that, and I do take it as a sign that at least some of our opponents are not operating in good faith, because that really is an argument that doesn't make any sense.
Okay. And then I was curious whether police organizations were for or against the act.
So the local police organizations were against the act. Law enforcement was probably our biggest source of opposition. One of the groups that we have been working with is a group of retired law enforcement. They're called LEAP, Law Enforcement Action Partnership. And they've been a really interesting group in terms of both advising us on the bill itself and then also helping us with outreach efforts. They're a group of retired law enforcement who, the way they would describe it is they feel that they have a lot more freedom now that they're retired to speak their minds about what they actually think about law enforcement. And that's a group that's been supporting us since the beginning, and has had, some really helpful things to say about some of the reasons why this bill is better for law enforcement. Ultimately, this is a reform bill, and I think that there is a reflexive, opposition from law enforcement to anything criminal justice reform. To be honest with you, I haven't been able to work successfully with law enforcement in Springfield on anything, and I work on a very broad range of criminal justice issues. But I do think that I actually think that, I mean it when I say that I think this bill is better for everyone. I actually think that it also makes law enforcement's jobs easier, and it means that law enforcement can focus their resources on things, on more serious crimes and not on less serious crimes. We spend a heck of a lot of resources policing, low level, not very important stuff. And this bill's whole function is to focus the courts and police's resources on serious crime.
Okay. So my third question and last one is I wonder if there's a disconnect between the pots of money. So cash bail goes down, police budget perhaps is impacted negatively, jail costs go down, but perhaps that's a whole different bucket, whole different pocket.
Yes, well spotted. Generally, our police budgets are separate. So because they tend to be municipal. So those budgets are usually not getting hit by this question. The real bucket problem is that getting rid of money bond hits clerk's offices and courts, and the savings are going to come from jails. So we're going to have to advocate for that transfer. We're going to have to make sure that the savings from jails, we hope that most of the money from the savings from jails goes to communities, but to the extent that there is any kind of deficit in court budgets, that's where the money needs to come from, is from the savings that are going to be, yes, in that other bucket. And I think we can absolutely expect a fair amount of squabbling over that money, but I do think that overall, that's something that our counties are going to have to be very in tune with in order to manage that effectively. Akeisha, do you have anything you wanted to add there?
No.
Well, and I note that the deficit hasn't even started yet. They have a whole year.
Right. Yeah, and actually there was a study by the Civic Federation, which is a good government group that does a lot of financial math kinds of things. And what they found is that money bond is less of a proportion of county budgets than then certainly we had worried that it might be. So that news was some good news in terms of it seems very unlikely based on what they found that any county in Illinois is going to find themselves in really dire straits simply because of the end of money bond. Certainly there's going to need to be moving around money, and there may need to be some state bridge money to counties depending on what's going on, but nobody is facing financial collapse, which is good news.
Thanks.
Hey, Sarah, you and Akeisha have referenced research about the impacts of anti-money bond and people returning to jail or committing crimes while released. Can you tell us where we can find some of that research so that we can look at, be familiar?
Yeah, sure. I absolutely can. Trying to think, Akeisha, I'm trying to think if there's a public resource we have that actually has the sites.
That's what I was thinking too. I think if there's not already, we can send it afterwards because we have the site. They just put it somewhere where y'all can see it. That's not any of our private things on there. Then we can send to you afterwards.
Because we have a lot of if what you're asking for is like the research studies, like, yes, I have all of them. But we can definitely do a follow-up with some of those sites, and I can even attach PDFs if you want to read some of that for yourself.
Okay, well, we'll send it out to the people here when we receive it. So, because I think be really interesting to see what kind of studies have been done.
Yeah, I mean, that's very much my focus, like as a researcher, and I mean, it really is fascinating. And some of the results just couldn't be starker. And the big one is, that just when you jail people, their likelihood of being rearrested in the next year after they're released goes up 30%. And
they believe that's because the impact of the jailing itself has created conditions that make.
People lose their jobs, and they're often housing, and those are two huge risk factors for continued police interaction.
What happens in the system if, for instance, someone repeatedly doesn't appear in court, even after receiving notice or those kinds of things? What happens even if the alleged crime is not terribly, terribly serious?
Yeah, that's a good question. Essentially, the way the system works is that, well, first of all, a lot of the warrant provisions I talked about, where judges have options to sort of tread lightly with warrants, those are all optional. So at any point, a judge can revert to the warrant system to actually issue a warrant and arrest someone. In terms of repeat behavior, the way the system works is that a technical violation like failure to appear in court can still be punished by a pretty serious amount of jail time, but it can't be reason to jail someone until the time that they go to trial. On the other hand, if someone is arrested for a new charge, so a new Class A misdemeanor or felony, that is grounds for pretty swift revocation of pretrial release. So, like I said, the system sort of treats lower level problems less seriously and then treats higher level problems more seriously, I would say, than the way the current system functions.
My understanding is that the circuit clerk's office has already started a system where they're reminding people of their court dates.
Good. In Champaign County? That's great.
Yeah, Champaign County.
Awesome.
You are ahead of Chicago then. At least if you're giving it to everyone. Chicago's got like a pilot program, but
yeah. Minnie, you have a question?
Yes, and you may have, thank you so much. This is really important information, and it deserves to be heard by so many people. And we commend you for the work that you're doing and have done, and hopefully you'll continue, and we'll support in any way we can. My question is that in talking to mothers who have electronic surveillances on, is there a limit on how far they can go with those electronic bracelets on. For instance, the three people that I talked to said that had problems. You know, they wanted to go down to the bus stop to meet their kids, you know, get them off the bus. And they were called in on that. One lady said I needed to go down to the basement of my building to the laundromat, and I was you know, punished for that. And so, can you talk just briefly about that if you have time?
Yeah, Keisha, you want to take that one?
Sure. Yeah, unfortunately, what she's experiencing is far too common. And a part of the reason why we're talking about electronic monitoring being just an extension of incarceration, because it stops people from doing those basic things. Some of the things that went into place on January 1st of this year, it changes something like that. So particularly around like needing to go down the block, having reasonable movement, those things should be changing, hopefully for the person that you know right now. But are there any changes to how far they can go on their EM, Sarah? That's the
So
problem.
no,
Yeah.
this is, you know, and to be honest with you, there needs to be a whole other bill to deal with the full range of problems with electronic monitoring. One of the things that we're hoping, one of the things that we did change in the law is to say that movement can't be unreasonably denied. I would argue that telling you that you can't go down the street to pick up your kids from the bus stop is unreasonable. Now that's a lawyer argument that I would have to make in court, and that, you know, and that's something, but that's at least something that people have the legal tools to talk to judges about now, as opposed to just having, you know, totally blanket, whatever the judge says is exactly what goes. But the problems that you're describing are exactly the same problems that we see in Cook County. And what's really scary is that, you know, those can lead to like immediate reincarceration. So people sometimes don't even know, or, you know, they assume that what they're doing is reasonable. I mean, I used to represent people on electronic monitoring, and I had a guy who got locked out of his house and turned himself into the jail the next day, and ended up arrested and reincarcerated and charged with a new felony, because he was, you know, away from where he was supposed to be. And like, how are you supposed to function? So there's a lot more work that we need to do on electronic monitoring. This is really just the first baby steps towards reforming those programs.
For sure.
So do we have any other questions? So, well, we are at 8 o'clock, so I don't want to keep our speakers from their daily lives and daily activities. We really appreciate your talking to us here this evening. And so thank you. And this video will be posted on our YouTube channel, so you can tell your friends if you about it, so that other league members can share it and see it too. So we really appreciate your speaking to us tonight. And, you know, you've given us some food for thought. I think we're going to have to think internally with the league about what kind of follow-up we can do. And it's really, I think, important that we have speakers and we get this knowledge, but we have to do something with it. And so, so that's the issue here. And so I think you've given us a lot of good starting points for working to make sure this is working in Champaign County. So.
Awesome.
Thank you so much for having us. Really appreciate it. And I hope everybody has a really great night.
Okay.
Yes, and please follow up with us if you want any support thinking about like next steps you ought to take. There are some campaigns in Cook County that talk about how to recoup the money from the changes to bond to benefit communities. So reach out, please. You want to get involved with that or replicate it in your own county.
Okay. Well, thank you. And if you're sending the research information, then I'll make sure.
I will send that tomorrow when I have a chance to pull stuff together.
Right. All right. Thank you very much. And good night.
Thank you.
Thanks.